Yeah, thank you very much, Keith. And thanks to the attorneys of the Kansas State Bar for inviting me out. Hurricane Alice blew in and struck the intellectual property community last summer on June 19th. Also my 32nd wedding anniversary. So we didn't really celebrate CLS Bank as part of that important day, but it has been a day that has marked a big change in intellectual property. A lot of properties have been absolutely destroyed. Other properties seem to be fine. It just somehow passes over them. Practitioners wonder, where is a safe harbor? Is there a safe harbor? What do we do now? And what's the best way to respond? So my goal today is not really to help us hold hands and commiserate over what it was like in the good old days when you could just throw a processor in and you were okay. But my goal is to help us do more than hunker down through Hurricane Alice. I'd like us to be able to surf and actually have a good idea of what are the things that we can do, what are the things that anybody can do to make the best out of this situation. Shall we talk about whether CLS Bank is, Alice v. CLS is rightly decided, wrongly decided? Well, I think that's a great topic for another day, maybe when Congress starts debating how to fix Section 101. But right now, we just have to accept it. It's a reality. It's fallen in our laps, and we are the experts in dealing with this. So what is surfing in the wake of Hurricane Alice? Well, basically what it means is we have to get up on the board and take some tough steps, some things that may look intimidating. We're going to have to do some more work because it's a big wave. And what's going to happen as we do that, we're going to take a pounding. It's inevitable. But sometimes we may actually get our client's case through the gamut and outrun the wave. It just means getting up each time. We make our best case, and then we get up again, and we do it the next day, no matter what happened on this particular case. Not everybody here is a patent practitioner, so let's just take a quick review of what happened in the Alice case. In my thinking, Alice stands for three main propositions. First of all, a patent that's directed to an abstract idea is ineligible for patenting unless it contains more that ensures that the abstract idea is not going to be preempted from the rest of the world to use. Secondly, it stands for the proposition that whatever idea you have to do something more than just, say, implement it with a computer. And then finally, the proper framework for analyzing an Alice-based rejection is the Mayo case. Now, Mayo is really maybe bad for your arteries and stuff, but it's not that scary. So I have a Mako shark here. So that's my Mayo shark. That's what's going to go out and devour your claims. And the analysis framework is really two steps. First of all, we have to determine whether the claim is drawn to an abstract idea, whether it's directed to an abstract idea. If it is, it's in danger of being consumed by the Mayo shark. What we have to look for then is to see what else is in the claim that might save it and might turn the nature of the claim from one that's really directed to preempting an abstract idea to one that's just a practical application of an abstract idea that's limited enough to let it through the patent system and grant a monopoly on it for a limited period of time. The Supreme Court's analysis in the case, I felt like it flowed this way. First of all, you look and see, is it a claim that defines something within Section 101? A process, machine, manufacture, or composition of matter. And then you look and see if you can get rid of the claim by throwing it into a little hole called an exception to 101. So you can bring it in, but if it falls out of the hole, then it's patent ineligible. So the three main holes are laws of nature, natural phenomena, and abstract ideas. Then, if you find it going out the hole, you can see if you can catch it again. Is there anything in the claim that saves it? And we'll look at how to do that calculus a little bit later on. And finally, even after you do that, there's this undercurrent. If the claim in the end looks preemptive of the abstract idea, then you just kill it anyway, because we can't have a patent system that ties up these fundamental building blocks of human ingenuity, because otherwise humans won't be ingenious anymore. The storm analogy I thought was cute when I suggested the idea of this presentation, but where does that lead us? I don't think it really takes us to the place that we want to go. I think it's an incomplete analytical framework. It's true, there's a lot of destruction that has come out from Hurricane Alice, and it's true that it seems to have blown in out of nowhere, especially if you live in a small town called Softwareville, where everything in the whole town seems to have been flattened. But storms are unpredictable, and this one hasn't stopped. It's going to keep going for a long time. We have to have something better, because what we really need is action. We need action because our clients have spent millions of dollars, yen, rubles, euros, securing protection in the world of software-related inventions. We have to take action on their behalf, even if it's hard and uncomfortable. So the storm analogy only leads to what I call Alice-induced despair. And it looks like this. These are some actual comments from one of the big patent blogs. The way it works is that any software application is now presumptively invalid. In reality, there's little to no hope right now. And then finally, the patent judges, they're death squads. So I don't think that that takes us where we need to go. Remember this is a catchphrase from an earlier presidential campaign. Any guesses? I forgot, we're in the Midwest. This is hope and change, okay? And as former Mayor Rudy Giuliani said during the 2008 campaign, change is not a destination any more than hope is a strategy, right? So despair is also not a strategy. Really, action is our best friend. And I think the way that we want to look at the Alice case is in a more of a clinical sense, a more of a compassionate sense. We need to take a Hippocratic oath with respect to the claims in front of us and do no harm, and we need to save what we can. So I prefer to think of this as more of an infection, E. coli. And if you get an E. coli infection in your claim, you have Alice-itis. And Alice-itis is a very virulent strain. It's not really the Spanish flu of post-World War I that killed 25 million people, but it's serious for our clients. It's very important. And really, this sort of approach makes a lot of sense because we can look at it as a population that exists at the time of the outbreak. That's the cases on file now that we're trying to deal with. And then a population that is yet to be born that may have some immunity built into it as a result of the things that are going on today. So there is hope for a future. But there are two different actions. We can vaccinate and we can prevent Alice-itis from going on, but as you see in the picture of the surgery ongoing, there are a lot of cases where you can't do anything but treat. The treatments are limited. So we're going to talk first about the treatments and then go on to prevention. The best treatment for Alice, in my opinion, is to recognize that Alice is a very analytically rigorous case. And whose job is it to make Alice rejections and support them? Well, it's the examiner, it's opposing counsel, it's whoever is trying to challenge your patent. They have to do that hard work, and unless they do their work, unless they carry their burden, we're not going to give them a pass any more than we do on prior art. So a healthy injection of Alice itself is going to become our best friend in this situation. So here's the Mayo shark test. Remember, there's two steps. The way it works is that if you don't win on step 1 as the patent examiner, you don't get to go to step 2. So if we can diffuse the argument at step 1 and show that the examiner hasn't carried his burden of making out a prima facie case of patent ineligibility, he doesn't get to go to step 2. And because we represent clients, we're going to do everything we can to point out where the examiner's logic fails, or where the examiner hasn't really done the job, because until he establishes that prima facie case, we really have no obligation to respond substantively. Now, we may choose to respond substantively in the spirit of compact prosecution, moving the case forward, that kind of thing. Now, how do we know if a claim is directed to an abstract idea? Well, the long and the short of it is nobody knows the answer to this. Justice Thomas, when he wrote the opinion, which is included in your course materials, he said, we don't really need to define the contours of where abstract ideas start. And my thinking was, well, oh, come on, Clarence. This was the perfect time to do it. That's what this whole case is about. But no, he ducked that one. So the Patent Office, I think, has done a reasonably good job. They've come out with 2 sets of guidelines. The one first came out, some interim guidelines, in the summer of 2014, and then the ones that Bruce mentioned, December of 2014. They're in the course material handouts, and you can find them. Okay, so these are the guides the Patent Office has put out. So these are worth looking at, because examiners go by that. If you're in the Patent Office for your forum, talk their language, use their training materials. If they're not following them, you can make some good progress there. Also, there are a limited number of decisions out there. I cite some of them in the course notes. DDR Holdings is the only one at the Federal Circuit that really helps us at this stage. This is where there was, you remember PayPal in the old days, where if you went to a website and you wanted to buy something through PayPal, you'd click the PayPal link, you'd go to a site that looked and felt different from the site you were at, and then you would purchase things there and you knew you were in a different place. DDR Holdings is about making even that last piece look like the website that you're at. And so the claims were held to be not directed to any abstract idea, even though it's e-commerce related, but to something that makes the web and the web page work better. So DDR Holdings, the judges there gave a good summary of the case law. So between the PTO's materials, between the Supreme Court cases, between the Federal Circuit cases, we have some inclination as to what are abstract ideas. But it's a small set. Let's take a look through them very quickly. This slide's all about mathematics. So if your claim has these things in it, the examiner's probably going to hit on those and say, look, that's a reason that your claim is directed to an abstract idea. And maybe that's what your claim has to have in it. I don't know. If you can leave it out, maybe that's better. Fundamental economic practices. I didn't know these were fundamental economic practices, but here are some things that count. Intermediate settlement, using advertising as currency, and then transaction performance guarantees. Conventional business practices, including automating tasks that relate to insurance policies, managing bingo games, and managing life insurance policies. Okay, I think they're pretty broad, abstract ideas. I feel comfortable enough with those. Certain methods of organizing human activities. Bruce mentioned that, what is that? What is that about? Judge Dyke, when he wrote a section in the Bilski opinion before the Supreme Court got it, he gave a review. He looked back through ancient patents from England, and he drew a distinction between human activity that was manufacturing related and human activity that wasn't. So if you're making a plowshare or whatever they did back in England in those days, if it was related to manufacturing, it came in under their patent statute. But if you're maybe doing a layup using a ballet maneuver like Michael Jordan, then that's just human activities. That's the best I can get on that one. An idea in and of itself is an abstract idea. It's pretty wise, right? Okay, abstract ideas are ideas. Now, these abstract ideas form a small set, and they should all be about the same size, something that is worth protecting from preemption. So in my book, and this is not right out of the case law. In my book, if we're going to protect it, it must be a building block of human ingenuity, right? That's what the whole preamble, the whole first couple of pages of the Alice opinion are. We're so concerned about protecting the building blocks of human ingenuity, we're going to give them special protection by making them an exception, a little hole through which your ball can fall into in section 101. So if you have a building block of human ingenuity that you're going to preempt, then your claim is no good. Now, not every abstract idea amounts to that level of breadth. Let's say I have a very specific idea. Well, that can't be a building block of human ingenuity. There's some level where the building blocks of human ingenuity stop, and the rest becomes the dust of the things that we create and invent. So really, the examiner is on safe ground. The examiner is in a safe harbor in only a few limited circumstances. Only when he's in one of these short examples that has been held to be a building block of human ingenuity that amounts to the abstract ideas that have to be protected. If he steps outside of there, he may have a good reason for doing it. He may be right, or he may be wrong. But that gives us a place to argue. So, what we have to do is to slay the Mayo shark. We have to start right here and not give an inch. So on step one, where the examiner says there's an abstract idea, we need to fight that. This is the form paragraph that the USPTO gives to the examiners. They're going to paste it in. It's an automated system, and you guys have seen this many times before, I'm sure. The first place where the examiner can fill something in is right there. And that's the first place where we have to take a stand and dispute the examiner's position. So how do we do that? Well, there is some problem that we can attack because we're lawyers. We're paid to spot issues and come up with arguments. Well, the idea is either too broad, it's too narrow, it's not abstract at all. We're going to do something like that and just get the mindset that the examiner is wrong from off the bat. How can we show it? Claims 1 through 12 are directed to alerting a person of event, which is a fundamental economic practice, and that's an abstract idea. So Tuesday, I went and I just pulled all the office actions that we got in that had 101 rejections, and I picked this one. This one is the shortest. This is an actual published case. So this is the actual rejection. So how do we attack it then? Well, we find this abstract idea, alerting a person of event. Is it in the claim? Well, here's the preamble. A game device for doing stuff. I don't see alerting about events anywhere. Alerting's not there. No, not there. It's nowhere in the claim. Alerting person of event isn't in the claim. There's so much more in the claim. So I would challenge the examiner's formulation of the abstract idea right here and say, look, you say this is some abstract idea, but that language isn't anywhere in the claim. You've clearly got the wrong abstract idea. So if the abstract idea is not based in the claim language, where does it come from? Well, the examiner's got to analyze it, got to explain where did they get that from. So here's one example. Examiner asserted our claims are directed to X. X is not mentioned in the claim at all, and the examiner had no analysis. Therefore, the examiner didn't make out a prima facie case of patent ineligibility. He didn't win on step one. We don't care what he said about step two at that point because we win, and he has to come back. Now, will the examiner give up? I don't know. Different examiners are going to do different things. Some will make good rejections, some will make bad, some will respond to our logic, some will just cut us off and say, oh, final rejection. Just repeat it and send it back to you. Is that idea of alerting a person of event even on the list of the short list of things that have been actually held to be abstract ideas? It's not on there, is it? Well, let's run through the list and take a look. Did he say it's a mathematical algorithm? No. Did he say, oh yeah, he did say it's a fundamental economic practice, but it doesn't really match any of those held by the Supreme Court or the Federal Circuit to constitute protectable abstract ideas that rise to the level of building blocks of human ingenuity. So we can attack him there. Now, he may be right, he may be wrong, but wait a minute, he said it's what? He said it's a fundamental economic practice to alert person of event. Alerting person of event, it's not economic. If it is, I don't have any proof of it. Now, how many of us have seen rejections over prior art where the examiner says, well, this is generally accepted prior art, or it's notoriously well known that whatever you have claimed is already known. And he can't find the one thing, or he doesn't think it's necessary. Do we give him any quarter for that? No, we always reject that. We say, I don't accept that whatever it is notoriously well known. You got to come up with proof. And he has to come up with proof of this too. He has to prove that alerting person of event is an economic practice. Even if it's economic, is it fundamental? Is it a building block of human ingenuity, or is it just something economic related? If having something economic related took out your claims, well, we'd be back before State Street, where it's just anything economic is just automatically unpatentable. So we attack every step of the way. We don't give an inch. We argue every point because the examiner's got a big job to do. Alice is an analytically rigorous case. So it's not our job to do the examiner's job, and we're not going to let him have a pass. So let's make sure that the prima facie case of patent ineligibility is something that the examiner does. But we don't stop there. Let's go ahead and attack on point 2 as well, because the examiner may just say, look, here's some more analysis, and then maybe he proves his case. But to finish slaying the Mayo shark, we have to attack on point 2, and that's more of a mathematical balancing act. Here, in step 2, what's wrong with his analysis that it's not significantly more? Well, who knows what significantly more is? The same guy that knows whether it's directed to an abstract idea, right? Nobody really knows exactly what that is. So that's good for us lawyers, because we have argument, and we can put rhetoric and logic together and make a compelling case. So either the examiner's logic here is insufficient, non-existent, technically wrong. It could be some other things, but we have to use some of these to get our creative juices flowing again. The examiner is going to say that certain things in your claim are generic computer elements that don't amount to more. Well, how is it that some things are generic computer elements? Okay, processor, I'll give you that. Memory, okay, that's pretty generic. A file system, yeah, we all know what's generic, but I think it's rare that all the elements of your claim are recited in just that way. If that is all your claim has, okay, maybe step 2 isn't where you win. But we're going to take a look back at our claim. What about all the elements that he didn't mention? Examiners who are in a hurry are not going to mention everything in your claim when they do the calculus of which is it substantially more or is it not quite enough? And he's not going to analyze why aren't they significantly more. I think examiners have to do that. That's part of their obligation in this 2-step Mayo test. Here's what my examiner wrote in this particular case. The claims do not include additional elements that amount to significantly more than the exception because the mere use of a game device and processing needs amount to nothing more than a general purpose computer. Each claim has been analyzed separately, it's good, and the same analysis applies to them all. So he pointed out these 2 items and said, well, this is just a generic computer. There's no more than that. So if we map it, he mentioned this and this. What about everything else in the claim? What about all that stuff? All that was ignored. Why doesn't that count on our side of the balance towards significantly more? Well, it does. It does. So the examiner should have to prove that the things are generic computer elements, and he should have to show his entire calculus. We have a lot of things on our side. Here there's an operation target control means for doing something, okay? It does some specific things. And why is that a generic computer element? Does every computer have And operation target control means that moves an operation target. I don't think so. I've never had a computer that has that. I bet if the examiner pulls up his computer where he spends his day, he doesn't have one of those on his computer either. It's definitely not a generic computer element. Now, what if it's implemented in software? Well, you just argue that this is part of my structure. My structure is a special purpose computer. It's special purpose because it has been programmed in a certain way that transforms it from something you buy at Best Buy to something that does this particular thing. So that's part of my structure. You can't just say that this doesn't count. We have first determination means that determines some things based on other things. That's not a generic computer element at all. And we're going to point that out to the examiner. And then this other thing, there's a lot of stuff in here that the examiner didn't even mention. In addition to saying we have more than just a general purpose computer because we have these other elements, we should also point out that it is significantly more. Because this is part of the strategy to move the case to allowance, to move the case past the one-to-one rejection. And here, the examiner has to consider each and every element. The Supreme Court spent 500 words plus analyzing each and every element in the Alice claim and considering them as the so-called ordered combination, a combination of elements. So the examiner, in his analysis, is supposed to specify that he looked at this, he looked at this, he looked at this. He has to look at every single thing, and then he has to look at them together as a whole. If the Supremes can do it, the examiner is supposed to do it too. There's no analysis of that kind here at all. It's just missing. This is a conclusory analysis. And the problem with the conclusory analysis is it doesn't really give us specific things we can attack, but it leaves us the whole job to attack everything. I say, as attorneys, we ought to attack everything. This is a mathematical question. We have two things. We have an inequality, don't we? We have something on the left, we have something on the right. We're either going to put a less than, a greater than, or an equal sign between the two. How do we make that calculus? Well, I think you just set up the equation. And the goal is to get yourself into a winning equation. And I think this next set of slides is key to today's presentation, because long-term, if you engage with an examiner who's willing to actually give you the analysis back, you can still move them past the one-to-one rejection by adopting the strategy that we're going to go into here. Will it always work? Well, of course not. It's just like negotiation classes, where once you go through, you feel like you can go to McDonald's and get 10 cents off the cheeseburger. But it's not always going to work. But it's still a great strategy. We have to look here at the abstract idea in the terms of A. Okay, so whether the abstract idea is a bona fide abstract idea, a kind of building block of human ingenuity abstract idea, or it's just like a crap abstract idea that the examiner pulled out of somewhere, we're just going to represent it by A at this stage. We're balancing it off against the claim elements. Elements 1 through n. There's a lot of elements there. So we're going to determine whether or not the abstract idea is in counterpoise with the sum of all the claim elements and see which comes out heavier. Now the problem, if they're equal, is that in the calculus here, it comes out to infinity. Basically, if your abstract idea and the claims and claim elements are about the same thing, then you preempt that abstract idea in an infinity number of situations. It's way too broad, and the building block of human ingenuity has been captured by whoever got that patent. Now, that's usually not going to be the case. Let's start with a broad recitation of an abstract idea, like we had in this case, where the examiner said, what was it? Alert person of event. Okay, so we're alerting a person of event. That's very succinct. It's a broad idea. It's a broad abstract idea. So how do we defeat that? It's not too hard. We have to just show that the sum of all of our claim elements is more. He mentioned two. He said there's abstract idea and there's these two things. There's processor and game device. That's all he weighed in. But what we're going to put in on our side is all the things that he left out. he left out completely at least 3 paragraphs of the claim. We add them on, and it comes out to be more than it was before. And we argue, of course, that that's a significant difference. So when you consider all of our things, our 2 determining means, our operation control means, and whatever else was ignored by the examiner, we come up with a sum that's bigger than what he has. It's because he has such a lousy abstract idea, right, that we can outweigh it. Now, whenever the examiner's abstract idea is broad, in other words, when it's succinctly stated, it's easier to outweigh that by throwing in everything from the claim that you can think of, right? So what's the examiner got to do? He's got to go back and say, look, maybe I didn't really do everything I ought to have in that office action. I'm going to refine the abstract idea and tie it more to the claims, because it makes sense. If I'm saying the claim preempts something, shouldn't the terms of the claim at least appear prominently in the abstract idea, right? I think that's very compelling. So the examiner is going to go back, my ideal examiner is going to go back and give you a more specific and detailed recitation of the abstract idea. So I did the work for him in this case and said, okay, now the abstract idea is not just alert a person of event, it's doing it while keeping track of timing and these other things and the game piece positions and whatever else the claim said. I didn't write the claim, I didn't really study it here. You don't have to. So the examiner now has a very specific abstract idea. Isn't that kind of a misnomer, a specific abstract idea? Is that a building block of human ingenuity? Well, the calculus comes out very bad for us in this situation because the abstract idea, A, is so large that no matter what else you throw in from the claim, you can never outweigh that. And how does that help us? Well, it doesn't help us in this equation, but the abstract idea is now so specific that it's no longer a building block of human ingenuity. It's the kind of thing that it's okay to give a monopoly on. It's the kind of thing that the courts aren't really trying to protect and prevent from being preempted. So if the examiner defines the abstract idea with more words in a more specific way, the odds go up that it's no longer a building block of human ingenuity. We can point that out, and we can argue that, and we can get him past the point to where this exception is going to apply, because the exception to 101 only applies in limited circumstances. There's some great language in the Supreme Court case that they're concerned that every case at some level involves some abstract idea, and so that's not a sin. It's a sin when you're trying to preempt one of these building blocks. The idea gets so specific when you make the examiner tie it down to the claim, if it's a good claim, that you can overcome the rejection this way. So when the idea is stated with more specificity, it's easier to show that it isn't the kind of idea that counts under Alice as one that you have to let slip out under 101. So the basic strategy: fight the rejection every step of the way. Attack whatever the examiner selects as the abstract idea. Try and force him to redefine it using the language of the claims. And then he'll get more specific. Once he gets specific enough, you can push it past 101 because it's no longer all that abstract. It's a kind of a detailed idea. To get a good patent, we all know you need 3 things: good specification, good attorney, good examiner. You can get by with 2. In the world of treatment, you just are going to have to get by with the specification that you're dealt with. Get on the surfboard, take your pounding, and move the case forward as best as you can. But what about cases that aren't written yet? I have a few very short ideas about what we can do to help inoculate the specification against Alice-itis. I think the best vaccine is the well-written specification that focuses on some technical feature, because it seems like the safe harbor now is getting claims that are more like those in Diamond v. Deere, where they improve some technology. And even Thomas, in the Supreme Court opinion said that, well, he didn't really say this. He did point out that, for example, this claim doesn't purport to improve the functioning of the computer itself. So that was one reason that he thought it was drawn to an abstract idea. So this seems to me like the best approach for a safe harbor. Find some way to improve the technology of your case. And how can you do that? I think it's pretty easy. In the software-related art, you just have to do it. This is the claim in Alice. I put a couple of extra things in here that I think might have carried the day. Who knows? We're not going to rewrite history. But instead of having it be a method of exchanging obligations, I use that as the context. And I say, well, it's a method of increasing data integrity when exchanging obligations. That's the focus. It's not really about the business method. It's about data integrity. So how do we do that? Well, we secure these shadow records. You would be doing that anyway, right? You're not going to let people access their own shadow records. This is all internal. You do data integrity checks sometimes, and you repeat them other times. And here's my out-of-the-box thinking. Add a whereby clause. You know, we all learned in patent class that whereby clauses are just little things you can add to the end. They don't receive patentable weight. They could cause mischief, so leave stuff out that could cause mischief. It may be what we need to start doing to help us through, whereby the data integrity is increased. Okay, it's not really saying much more than the original claim did. Everybody wants a system of data integrity. It's not all that much narrower, but I think this might have caught Justice Thomas's eye, and he might have said, this claim really is directed to the functioning of the computer itself, enough to where at least we get out of 101 and into the prior art. That's where the real discussion should be on these kind of claims. My honest opinion, I like the protection of software by patents. Not everyone is of that camp, but we should be fighting it out in the world of prior art. 101, you just got to get past it so that you can get into that next world and debate those things. This is some sample arguments that you can make. Point out that your claims are drawn to the functioning of the computer itself. That kind of automatically is going to get you out of the whole Mayo test because you're winning on step 2. You're showing that it is significantly more because significantly more is satisfied by improving the function of the computer. You automatically win there. If the examiner doesn't let you in, you take it to the board because that is basically a safe harbor. The claims target the increase of data integrity. This is the Alice claim. And you compare it, like a claim with less data integrity, a computer with less data integrity isn't as technically advanced as one that has better data integrity. So this is a technical improvement in the computer itself. Here's some ideas. I put them in the study notes as well. Ideas of where you could look to find improvements in a software-related invention. Reduce the number of CPU cycles that are being used. Reduce the amount of memory that you're using. Increase parallel operations. Reduce power, speed up retrieval, reduce storage. I mean, none of these things are rocket science. And if you have an invention that you're working on with your clients, you could say, look, I know it's all about this, but we really need to put in some technical moxie here to show that it's drawn to improving how a computer works. So is this increasing throughput? Can you show how data integrity is improved or security? All those things relate to the functioning of the computer. And here are some others that are more user interface oriented. The whole goal in the prevention, the vaccination process is to build your specification so that when you do run into an Alice rejection, that you can get past it and get into the prior art where the real battle should be fought. Pick a fight if you're in treatment. Start and don't give any quarter. Make the examiner carry their burden with respect to every single analytical point. Alice is a rigorous case, so pick a fight there. Don't give a bad rejection a pass at all. You wouldn't do it with prior art, and we're not going to do it with patent ineligibility. With respect to prevention, if you're in a world where you can actually have an input on how the specification is written, tech in the spec. Tech in the spec is what's going to give you fodder later on to fight against the Alice-based rejection. Right now, the set of abstract ideas, building blocks of human ingenuity that have been held to be such is pretty small. By the time whatever you're writing now gets under examination, it's going to be bigger, it's going to keep growing. But if you put enough technology in there, then that will give you at least something to argue. So you're not expected to save the patients that are terminal. They just can't be revived. You just fight for them as much as you can. Advise your clients, yeah, this patient only has 1 week to live. There's really nothing we can do. Give them a fair and honest assessment. If they want to go forward, that's their choice anyway. You're just the helpful expert that they're looking to for advice. But even though you can't do the impossible, you can do a lot. And you can put on your boxing gloves, or you can pick up your surfboard and hit the waves. So to everybody here, I wish you happy surfing. Thanks.